Hello?
Good afternoon, Judge. This
Good-
is Javier Chavez on behalf of the Public Defender's Office.
Good afternoon, Mr. Chavez. Thank you for your patience down there. All right. I'm sorry? Okay. Is it, all right, state who's appearing today?
Matt Kozera for the state. That's K-O-Z-Y-R-A for the record.
All right, thank you. And can we call our first case? Oh, I call them. There's not a clerk to call them. All right, I can call them. All right. Mr. Battalius, this is, I don't have a court case number for this one.
Yes, Judge. Mr. Cesar Battalius, I'm going to ask you to reset it for tomorrow.
Okay. All right, so then that brings us to Ms. Banyarde.
Here she comes, Judge.
All right, thank you.
We're going to ask that you consider setting a bond on this case. I understand it is a felony violation of probation, but we're going to ask that you set a bond, or I'm sorry, misdemeanor.
What was that about a misdemeanor?
I'm not 100% sure, but it might be a misdemeanor violation of probation.
Oh, I see what you're saying. All right, so ma'am, you've been charged with a violation of probation. I'm going to find probable cause, and I'm going to provisionally appoint the Public Defender's Office for that, and I am not going to set a bond.
All right, thank you, Judge.
Thank you. And then that brings us to Mr. Bonilla. Good afternoon, sir. Sir, you have been charged with a failure to appear on a written promise, or that's what you were arrested for. I've reviewed the affidavit. I find probable cause. I'm going to provisionally appoint the Public Defender's Office to represent you, and I am not setting a bond on this matter. That brings us to Mr. What is it, Clas Quinones? And sir, you were arrested for a violation of probation or community control. I find probable cause, and I will provisionally appoint the public defender to represent you. And given the nature of the charges, I am not setting a bond. And then we have Ms. Diaz. I can't really read the handwriting on her last name.
Yeah, it looks like it's Maria Diaz Ciares.
Ciares?
C-I-A-R.
R-E-S, okay.
Yeah,
Diaz
Ciares.
Ciares, okay.
She's on her way, Judge.
Good deal. Good afternoon, ma'am. So this is charge, ma'am, is aggravated battery with a deadly weapon. I have reviewed the affidavit. I find probable cause. I am provisionally appointing the public defender. She does qualify for pretrial release. It's an unusual circumstance. Have we heard from the victim?
Officer Dunkirk with PTR. I actually spoke to the victim. She will be at the residence until next Wednesday. She wishes to have no contact, but this is Ms. Diaz's home. So she's asking the court if we can allow at least one, till next Wednesday, for her to be removed from the house as well as her belongings.
Okay, I'm having a hard time hearing. Is there a way to turn up the volume?
Can you hear me now?
That's much better, thank you.
Okay, sorry, Judge.
No worries.
I spoke with the victim, and she will be leaving the residence. She needs time to gather her belongings. She said Wednesday she'll be out.
So does the victim live in the defendant's home?
Yes, Judge.
Counsel, what do you suggest we do in this circumstance?
It's kind of an interesting question, Judge. I would say no contact, but I think she can return to the residence since it is her residence.
Judge, Matt Kazera for the state. State's
Yes.
position on this would be no contact, no return, maintain separate residence. If in fact the victim does move out as she's planning on Wednesday, then at that point it would be appropriate for the defendant to file a motion to modify that no contact order. But the intent of the Florida legislature in Chapter 741 was not to have victims need to move out to avoid contact with defendants, even if it is the defendant's home.
All right, it's a little bit
Judge,
different
just to be
situation
clear.
in that this is not a marriage.
Judge, just to be clear, the victim did say she was moving out. If you allow the defendant to be PTR'd, we can also verify that the victim has moved out prior to the defendant moving back into her residence
Okay.
as a condition.
Mr. Chavez, would you ask your client if she has somewhere she can go in the interim?
Can you live somewhere? Yes, Judge. She said she can, pending, I guess, the alleged victim moving out.
Okay, so I'm going to grant PTR. Ma'am, I'm going to order that you have no contact with the alleged victim, and if you have items in your home that you need, I'm going to allow you to go to your home with law enforcement one time to obtain the items that you need until you can go back into the home full-time.
Okay, Judge, thank you.
Thank you.
And I'm sorry, Judge, just for clarification, is the order going to state no return to the residence as long as the victim is living there, or how is the order going to address that issue?
Well, I have a no contact, and it's the defendant's home, so I'm just going to leave it at no contact with the victim, and PTR is going to verify that the victim has moved out as represented, and the Public Defender's Office, I'm sure, will file an appropriate motion if the victim has not vacated the premises as represented. I don't know, I didn't have any indication that there's any kind of a formal lease or any right to be in the home other than as a guest. So I'm not going to burden the defendant any more than this already has. So no contact with the victim. As long as the victim's living in the home, the defendant cannot live in the home, but she can go one time with law enforcement to get any belongings she needs in order to live elsewhere until the victim is out of the home. I hope that is clear enough and sufficient.
Thank you, Judge.
Thank you. All right, that brings us to Ms. Garcia Martinez. Good afternoon, ma'am. You've been charged with one count of battery. I do find probable cause. I am appointing the public defender provisionally to represent you. I will grant release through PTR, and I'm going to order that you have no contact with the alleged victim. No contact means no direct or indirect contact.
Judge, I spoke to the victim, and they request to have a no hostile contact.
Okay. I will grant that then, no hostile contact. Yes, sir.
I'm sorry, Judge. Is the victim present? I don't know whether the.
Is the victim present
I
in us?
advise the judge,
I'm sorry?
because we're in a jail, no, so I advise them to go to Orange County. But I did speak with him directly.
Okay, thank you.
Judge, we have Attorney Tinsley here. He is here for Anthony Rodriguez.
Anthony Rodriguez, okay.
Stand right here. Good morning, Judge. Stephen Tinsley, counsel for Mr. Rodriguez, who's with me to my immediate left.
Good
Your
af-
Honor, Mr. Rodriguez is, good afternoon.
I'm having a hard time hearing you.
Sorry about that. Is this better?
That is, yes.
Is this better? Okay, very good, Judge. Stephen Tinsley, counsel for Mr. Anthony Rodriguez, who's with me to my immediate left. Judge, Mr. Rodriguez, while he was living in South Carolina, pled to 2 misdemeanor charges in New York. They had him register as a sex offender in New York, but he wasn't required to register in South Carolina. And when he was transferred down here, he didn't realize he had to register. So that's one issue. 2, we don't know what kind of registration requirements New York has, because he's supposed to have the very lowest there is. However, we're asking for a $1,000 bond. We're asking that he not have pretrial release conditions because he's closing on his new home on the first week of June, and it's in Polk County. He works in Orange County, and he's going to be moving through 3 counties basically on a daily basis while he's employed. He has a very, very good job, and he's not a risk. He's not a risk to him or his neighbors.
All right. State, do you have any objection to the lack of PTR conditions? The bond requested is in line with what I was going to grant.
No, Judge. Leave it to the court's discretion.
All right. Sir, you're charged with failure to comply with registration. I did find probable cause, and you have a right to be represented by counsel of your choice, and it appears you've retained Attorney Tinsley. Is that correct?
Yes, Judge. We filed a notice of appearance last night by e-portal,
Okay.
or yesterday afternoon.
Okay.
I've been on the case for about 12 hours.
All right. Well, I appreciate you being there, and I appreciate your patience today, and I'll set bond at $1,000.
Thank you, Judge. Thank you, State. Have a seat. Thank you.
All right, and that brings us back to Mr. Gale.
Can we go ahead and reset him for tomorrow, Judge?
Sure. Let's see.
Yeah.
We reset Mr. Battalias for tomorrow, and we're resetting Mr. Gale for tomorrow. All right, so then we'll have Ms. Gutierrez. Good afternoon, ma'am. You've been arrested for battery, domestic violence. I do find probable cause. I will provisionally appoint the Public Defender's Office. Ms. Gutierrez does qualify for PTR. Has there been any contact with the victim to ascertain the victim's position?
No, Judge.
All right, so I'm going to grant PTR release, and I'm going to order that there be no contact, indirectly or directly, with the victim. And Mr. Chavez, would you ask your client, I believe your client has a child in common with the alleged victim, is that correct?
Yes, Judge.
All right, I'm going to order no hostile contact between the defendant and the victim. I'm going to allow them to have communication regarding their child. I'm going to require that they maintain separate residences until till the victim's position can be ascertained. And I'll allow Ms. Gutierrez one time to go obtain personal effects accompanied by law enforcement.
Judge, if I may, Matt Kazera for the state, just for the record, without any testimony from the victim and without any indication in the affidavit that she wants to have contact with the defendant, the state would object to any no hostile contact order being issued at this time.
Is there any basis for me to restrict contact with the defendant and her child?
Judge, what is typically done in these circumstances? The court has broad discretion to order no contact, no hostile contact, whatever it is that the court would like. What is typically done in these circumstances is either a third party is designated to relay messages regarding child care, or a no contact order is issued, and then the parties, the defendant can move to have that modified with regards to child care. I also don't know whether there's a DR case that governs their contact with each other.
I'm going to leave it as I ordered, no hostile contact and maintain separate residences until the victim's position can be ascertained. The victim did say to law enforcement that he did not wish to prosecute. So on that basis, I'm going to allow there to be contact, just not hostile contact, so that they can be parents. Mr. Chavez, anything else I need to address on that case?
Nothing further, Judge.
Thank you. All right, and that brings us to Mr. Garcia Martinez.
Judge, can you go ahead and reset that for tomorrow?
All right. So that brings us to Mr. Jones. Good afternoon, Mr. Jones. You were arrested for an out-of-county warrant in Brevard County. I find probable cause. The public defender is provisionally appointed. There is no bond. Brevard County will be over to pick you up, and you will see a judge there when you arrive in Brevard County. Anything further?
I thought I had a bond. They told me I had a bond.
It's an out-of-county warrant.
Yes, Judge. Does he have $1,000 on the out-of-county warrant, Judge?
Oh, let me look and see. Is that what this amount is?
Yes, Your Honor, I believe so.
Okay,
Purge, Judge.
let me look.
I believe it's a purge for child support, Judge, of $1,000.
There's a purge of $1,000.
Typically, if he doesn't pay the purge, he'll be transported over to Brevard County.
Okay, so it's a purge, not a bond?
Yes, Judge.
Okay. So there is no bond, but the purge amount is $1,000.
So that means I can pay that and I'll be out.
Have a seat, whoops.
Right? And that brings us to Mr. Jordan. Good afternoon, Mr. Jordan. You have been arrested on 28 counts. No, 27 counts, excuse me. Counts 1 through 9 are sexual battery on a victim under 12 years of age. Counts 10 through 24 are lewd or lascivious molestation, victim under 12 years of age. Counts 25 and 26 are lewd and lascivious conduct, and count 27, lewd or lascivious exhibition. I find probable cause. I'll appoint the public defender provisionally. There is no bond, and I am ordering no contact directly or indirectly with any of the alleged victims. Anything further, Mr. Chavez?
No, Judge.
Thank you. All right, that brings us to Mr. Mascara.
Judge, he's in the hospital. Can we reset him for tomorrow?
All right, we'll reset Mr. Mascara for tomorrow. That brings us to Ms. Montero. Ms. Montero, I believe, has 3 cases. Good afternoon, ma'am. So you have been arrested in 3 separate cases. It's the same arrest number. Do I need to distinguish any particular numbers on the record?
The case number of the arrest warrant, Judge.
Judge, on the first page.
Oh, there, I see. Okay. This is 19 CF 1679. You're charged, in that case, you're arrested for trafficking heroin more than 4 grams and under 30 kilograms. I find probable cause. Ma'am, you have the right to be represented by an attorney. I believe did you request the appointment of the public defender, ma'am?
Yes.
Mr. Chavez, did she say yes?
Yes, Judge, I'd ask that you appoint us on all 3 cases.
Okay, so that's what I'll do. In case number 19 CF 1680, the charge is similar, trafficking heroin more than 4 grams and under 30 kilograms. In case number 19 CF 1681, same charge, trafficking heroin more than 4 grams, less than 30 kilograms. In each case, I will set a $100,000 bond with PTR conditions. And that's $100,000 per case.
Thank you, Judge.
All right, and that brings us to Mr. Odell's case.
Judge, is this Dennis Odell?
Dennis Odell, yes.
He's in the hospital. Can we reset him?
Yes.
Thank you, Judge.
All right, and then that brings us to Mr. Perez Rodriguez.
Yes, Judge, and we're going to need a Spanish interpreter for him. if he's
Okay.
here.
Good afternoon, the interpreter's present.
Perez Rodriguez. Mr. Perez.
Mr. Interpreter, are you ready?
Yes, Your Honor, for the record, this is Jorge Bonilla, State Certified Co-Interpreter.
Okay, have you been sworn?
No, Your Honor.
All right, raise your right hand, please. Do you swear or affirm to truthfully interpret from English to Spanish and Spanish to English in this matter?
I do.
All right. Mr. Perez Rodriguez, you have been arrested on 2 charges. One charge of grand theft, more than $300, less than $5,000, and one charge providing a false name or identification by an arrestee. I'm going to provisionally appoint the Public Defender's Office in this case. I do not find probable cause for theft based on the description in the affidavit. I do find probable cause for the false name or identification by an arrestee. State, how would you like to proceed given my finding with regard to the theft charge?
Señor Pérez Rodríguez queda detenido bajo 2 cargos. En el primero, hurto de mayor cuantía, mayor de $300, menor de $5,000. En el segundo cargo, se le acusa de dar un nombre falso por arrestado. Designo provisionalmente al defensor público. No determino causa probable por el cargo de hurto basada en la descripción dada en el affidavit, pero sí determino causa probable en el segundo cargo. Fiscalía, ¿cómo quisiera proceder basado en mi dictamen?
Judge, ordinarily, the state would ask for 24 to 48 hours to obtain a supplement from the law enforcement officer to try and shore up whatever probable cause issues the court sees. Do you mind my asking what concerns the court has with probable cause so I can address that with law enforcement?
I'm sorry, hold on one second, please. Señoría, normalmente la Fiscalía pide de 24 a 48 horas para ir a donde el oficial arrestante y suplementar cualquier argumento de causa probable. Su señoría, con su permiso, quisiera preguntar cuál era el issue con causa probable.
The problem I had with the probable cause was that the description was conclusory and provided no factual basis for the conclusions.
El problema que yo tenía con la causa probable fiscal era que era una determinación conclusoria y no tenía ninguna base fáctica en cuanto a esas conclusiones.
Judge, the state would just ask that we reset this for tomorrow in that case so that I can have the opportunity to try and get a factual basis from law enforcement for you.
All right.
Entonces, juez, la Fiscalía pide que se aplace esto para mañana para tratar de obtener una base fáctica de parte de las autoridades.
All right, so we will continue Mr. Perez Rodriguez's case until tomorrow.
Entonces, aplazaremos el caso del señor Pérez Rodríguez hasta mañana.
Thank you, sir.
Muchas gracias, caballero.
All right, so that brings us to Mr. Rodriguez Montano.
And he also needs the services of a Spanish interpreter, Judge.
All right, terrific. I had just continued it, so I wasn't going to address the bonds until tomorrow. Can I do that? That's what I want to do. So with regard to Mr. Rodriguez Montano, do we have the interpreter?
The interpreter is at the court's disposal or service.
Okay, does Mr. Rodriguez Montano have the headset on or whatever you
No,
use?
Your Honor. If it pleases the court could just address Mr. Rodriguez Montano, and we would do it consecutively, as, for example, one would do witness testimony in a live courtroom.
Got it. I can't really see what's going on down there. That's why I asked. Thank you.
No, well, Mr. Chavez and the defendant are in that chapel in the Osceola County Jail, and I'm covering both detention facilities from the Osceola County Courthouse, from my
Perfect.
office, in fact.
Perfect. Okay, thank you. All right, so Mr. Rodriguez Montano, you are charged in this case, you've been arrested in this case with battery, domestic violence. I do find probable cause, and I will appoint the public defender's office provisionally to represent you.
Señor Rodríguez Montaño, en este caso usted fue detenido y acusado de agresión física por violencia doméstica. Determino causa probable, designo al defensor público provisionalmente para que le presente en este caso.
Mr. Chavez, this is another situation where I have a question about who owns the home and who lives where. Can you ask your client if he has any insight for us?
Licenciado Chávez, este es otro issue donde tengo preguntas respecto a quién es dueño de la casa, quién vive allí. Si usted pudiese indagar a su cliente.
Yes, Judge, he lives with his family, but he can't find a place to live pending, I guess, a bond, a motion to, I guess.
Señoría, él vive con
I
su
guess
familia,
the-
pero creo que podría. Oh, one second, Mr. Chávez. Él vive con su familia, pero supongo que podría buscar un lugar a donde vivir, sujeto quizás a una moción.
But it also looks like the Department of Corrections actually contacted the victim, and the victim has requested non-hostile contact.
Pero tal parece que el Departamento de Correcciones contactó a la víctima y la víctima solicita contacto no hostil.
All right, and I did note that in the affidavit, the victim said that she would not pursue charges and would not testify in court. So I'm going to grant release on PTR. I'm going to order that Mr. Rodriguez Montano maintain a separate residence until the victim can provide direct input. I will order no hostile contact. So I'm not going to order no contact, but Mr. Rodriguez Montano needs to find a place to live until the victim can contact the state attorney's office.
Ok, entonces en este momento, bueno, señoría, la víctima dijo que no va a, dado que veo aquí que la víctima dijo que no iba a testificar y no procurar cargos contra el acusado, determino que el acusado quede libre bajo libertad con antelación a juicio, que viva en un domicilio separado hasta que la víctima pueda dar su relato directo. Se prohíbe el contacto hostil, no voy a prohibir el contacto en este caso, pero sí el acusado tiene que buscar a dónde vivir hasta tanto la víctima pueda dar fe directamente.
All right, and that brings us to, and thank you, Mr. Interpreter. That brings us to Mr. Scott's
Thank you.
case. Afternoon, sir. You have been arrested for aggravated battery causing bodily harm or disability. I find probable cause, and I will appoint the public defender provisionally to represent you. I'm going to set bond at $3,500 with pretrial release conditions. I'm going to order no direct or indirect contact with the alleged victim or the child. I'm going to order that Mr. Scott have no guns or weapons of any kind, and I will specifically reference Florida Statute 790.01001, or is it 011? Anyway, the statute that defines weapons and firearms. You cannot have any of those, Mr. Scott. And I'm going to order that you surrender the gun that is referenced in the arrest affidavit.
Surrender the guns to law enforcement within 24, Judge?
Yes.
Just for clarification.
Yes. Thank you. All right, and that brings us to Mr. Steitz's case.
Judge, can you reset him for Sunday?
I can. And that brings us to Mr. Taunton's case.
I believe he's bonded out, Judge.
All right. And so that brings us to Ms. Velez Reyes. Good afternoon, ma'am. You've been arrested for battery, touching, and striking. I find probable cause. I am going to appoint the Public Defender's Office provisionally to represent you. I'm going to set bond at $1,000 with pretrial release conditions, and I'm going to order no hostile contact. Has anyone made contact with the victim to?
Yes, Judge. I actually spoke with him, and he requests contact. I believe it's Mr. Jones, which you already previously addressed. And she does meet the criteria for a direct PTR. She has no convictions and only one prior.
Okay. So I will grant then PTR. And no hostile
So
contact.
no bond, Judge, that's just pretrial release.
Correct. If I heard correctly, she meets criteria, so I will, and the victim has requested contact, so I'm just going to put a no hostile contact condition on there.
Thank you, Judge.
And then that brings us to Mr. Victor.
Judge, he's already bonded out.
Okay. All right, and then that brings us to Mr. Campbell.
Judge, you're going to have to reset that for or is he here?
Judge, I'm sorry, my apologies. Judge, Mr. Campbell actually was IE'd yesterday in front of Judge Murphy. However, we advised him he has an open incompetency case, which he was out on conditional release. And the court order mistakenly put just regular PTR with mental health conditions. We advised the judge he is not qualified for a direct PTR due to the open case he went to court for yesterday. So we need a modification with bond set at $500 with pretrial release with mental health conditions.
So,
That way the gentleman has, he would be bondable.
So is it just a matter of modifying where the check mark goes on the order of commitment
Pretty much, Judge.
or the special conditions of release, rather? Because I did notice that under special conditions of release, PTR mental health conditions was checked, but then it was just straight PTR at the top of that document.
Correct, Judge. That PTR needs to be stayed, and then the bond with PTR conditions over to the left should be marked. Everything else is to remain.
Okay, so under special conditions of any release, bond with any conditions of PTR should be
Yes, Judge.
checked.
Yes, Judge.
And that
the
should
bond
be at
stayed at
$500?
Yes, Judge.
Okay. Does that make sense, Madam Clerk?
And just for the record, the PD was
Mental health
appointed yesterday.
PTR conditions. I'm sorry, what was that, ma'am?
The PD was appointed yesterday in IAs, just for the record, and that was PTR, bond with PTR with mental health conditions.
Yeah, I guess I want to make sure that that we do this correctly this time. So at the top, where it says original bond
The top.
$500, and then it says stayed PTR, ROR, MHPTR, should we place a check under MHPTR at the top?
No, Judge. It should be stayed, and that should be the only thing that's marked up at the top. And then under special conditions of release, there's bond with conditions of PTR as to count, which we only have one count. That should be marked.
Okay,
And then it should already have, over to the right-hand side of that, it should already be marked PTR with mental health conditions.
correct.
So as far as, yes, that's all we need amended.
Perfect. Okay, I think we've got that.
Thank you, Judge.
Thank you. And then this brings us to Mr. Hultquist's case. And Mr. Hultquist, you've been charged with, or you've been arrested for 3 counts, possession of a controlled substance without a prescription in 2 counts, in possession, use of drug paraphernalia in the 3rd count. I'm going to stay the bonds and appoint the public defender's office on this case. The bonds are $1,000, $1,000, and $500. I did note, state that the arrest affidavit has an incorrect date on it because it references a date that has not arrived yet.
Oh, that's certainly wrong then, Judge.
I felt like I could still make a probable cause determination based on that.
Yes, Judge, I don't disagree, especially since it's acknowledged on the 16th day of May down at the bottom, and then up at the top it says the 26th day of May. I think it's fairly clear that that was just a scrivener's error and somebody had 2 instead of a 1.
Correct. So I do find probable cause on that, and all right. I believe, anything further on Mr. Hultquist's case, Mr. Chavez?
No, Judge.
Okay, thank you. And then that brings us to the last 2 cases, which are Mr. Javier Rios Rodriguez. All right, sir. You have been arrested, and I have two cases here in front of me.
You understand English, right? Judge, we're going to need a Spanish interpreter for
Okay.
Mr. Rios Rodriguez.
The interpreter is present.
All right, sir. I have two cases in front of me.
Caballero, tengo dos casos ante mí.
In one case, you have been arrested for fleeing and eluding a law enforcement officer with lights and sirens active.
En el
Yeah.
primer caso se te acusa de huir o intentar eludir a un oficial del orden público con luces y sirenas activadas.
And the second count is operating a motorcycle without a license.
En el segundo caso se te acusa de operar una motora sin licencia.
In the other case, you have been arrested for four charges: possession and control of possession of a controlled substance without a valid prescription,
Y en el otro caso se te acusan de 4 cargos. El primero, posesión de una sustancia controlada sin receta válida,
possession and use of drug paraphernalia,
posesión y uso de parafernalias de drogas,
criminal mischief,
daños a la propiedad ajena,
and the fourth charge, possession of marijuana over 20 grams.
y el cuarto cargo, posesión de más de 20 gramos de marihuana.
I do find probable cause.
Determino que existe causa probable
And I will appoint the Office of the Public Defender provisionally to represent you.
designaré al defensor público de modo provisional para representarte.
And bonds will be stayed at the amounts previously set. So in the fleeing and eluding case with the operation of the motorcycle without a license, the bond will be $2,500 for the fleeing and eluding charge and $500 for driving without a motorcycle endorsement.
Entonces, determino causa probable, todas tus fianzas permanecerán en vigor. En los casos del primer cargo, se te fijan $2,000 de fianza en el cargo de huir o intentar eludir, y se te fijan $500 de fianza por conducir la motora sin la licencia válida.
And in the other case, concerning the drug charges, I'm going to stay the bonds that have been previously ordered in that case, which are $1,000 for possession of a controlled substance without a prescription,
Y en el otro caso voy a dejar también las fianzas en vigor según fueron impuestas. Quiere decir, en el primer cargo, posesión de sustancia controlada, se fijó una fianza de $1,000.
$500 for possession or use of drug paraphernalia,
$500 por posesión o uso de parafernalias y drogas,
$500 for criminal mischief,
$500 por daños a la propiedad ajena
and $1,000 for possession of marijuana over 20 grams.
y $1,000 por el cargo de posesión de más de 20 gramos de marihuana.
Mr. Chavez, is there anything else I need to address on those cases?
¿Algo más que yo tenga que tocar en esos casos, licenciado Chávez? No, señoría.
Judge? I'm
Yes,
sorry,
ma'am.
Officer Dunkirk with CTR. On case number 19 CF 1772, Judge Murphy ordered random drug and alcohol testing, also no driving without a valid driver's license.
Señoría, en el caso 19 CF 1772, el juez Murphy también ordenó pruebas aleatorias de drogas y conducir que no conduzca sin licencia válida, como condiciones de libertad con antelación a juicio.
All right, I do see that now. So those conditions will also remain. Random, is that unsupervised testing?
We'll schedule him for testing, Judge.
Muy bien, veo esas condiciones, así que las impongo.
It will
Pruebas
be done
aleatorias.
with these conditions.
Y eso es libertad con antelación a juicio con estas condiciones.
Yes, okay, I see that now. So it is the bond with conditions of PTR as to all counts in case number 19 CF 1772. That's the fleeing and eluding case.
Veo eso ahora, fianza con condiciones de supervisión bajo libertad con antelación a juicio en todos los casos, cargos del caso 19 CF 1772. Ese es el caso de huir o intentar eludir.
That will be, you'll be subjected to random drug testing, and
Quedará
random
sujeto-
drug and alcohol testing.
Quedar sujeto a pruebas aleatorias de alcohol o drogas.
And there will be no driving without a driver's license as a condition as well.
Y también se prohíbe el conducir sin licencia válida.
In case number 19 CF 1773,
En el caso 19 CF 1773,
the bond will be with all PTR conditions.
la fianza también será con todas las condiciones de libertad con antelación a juicio.
And that will also include the random drug and alcohol testing.
Y eso también incluirá las pruebas de orina o drogas al azar.
All right, anything further on those?
Algo más en esos casos.
No, Judge.
Not from the state.
All right, so I believe that concludes the Osceola docket. I appreciate everyone's patience.
What time will we be starting tomorrow, Judge?
Hope springs eternal. I don't know what time because I don't know how long we'll be at juvenile tomorrow morning. So I will do my best to be ready at 11, but I don't know.
Okay, Judge. I appreciate it. Thank you ever so much.
Yeah, thank you. I appreciate your patience.
No worries.
Put it at the top of, felony duty for the first month, felony duty. Who is that? Put it on top of Gonzalez. On top of Gonzalez, the first felony duty. Yeah, we're gonna do him now.
What do I do with these? Okay, and these are the ones for tomorrow. Okay. Oh, beers. That's good.
Now we got Fiorella on top of the felony DBs, because she's the only one with a victim, okay?
Pirello on top of the felony.
Yeah, she's a misdemeanor DB.
Oh, okay. All right, thank you.
All right. Are we ready? And they're in the
Just
order.
to confirm, from correctional personnel, are there still no interpreter cases for Orange County?
Correct.
All right, then with that, if the interpreter may be excused with our wishes for a good weekend for everybody.
You as well, sir. Thank you.
Thank you. Thank you, and have a great one, everybody.
All right, so this will be 19 MM 4196 ALO, Kiran Patel.
Afternoon, Judge.
Good afternoon.
Judge John Notary for Mr. Patel stands to my right.
Good afternoon.
Judge,
Yes, sir.
I'm sorry, there's a $500 bond on the new charge, which we're certainly okay with. I believe he's already posted it. But for some reason, there is a hold by the jail. Mr. Patel was just about completed his DUI diversion program. The bond had already been discharged in that case, so he's not out on bond, and we just asked the court to lift the hold so he can be released.
All right. Probably going to result in a revocation of the pretrial
That,
diversion, but
if
maybe.
they revoke, if they send it back to court, then we just start the other case back up again,
Right,
Judge. But
right.
He's
All right.
completed the program.
All right, so I will find probable cause. You're represented by counsel, sir, and I will lift the hold.
Thank you, Judge, I
Sure.
appreciate it. Thanks, Judge.
All right, thank you. Appreciate your patience.
Yeah.
He's posted the bond. So, yeah. It was just that hold on him, I think, that was the problem. Thank you. I'm sorry? Oh, give it to you when we're done. All right. So the next case will be case number 19MM4211. And that is Fiorella.
Morning, Your Honor. Megan Albrecht from the Public Defender's Office.
Yes, ma'am. Good afternoon. Ma'am, you are charged in this case with battery, domestic violence. I've reviewed the affidavit. I find probable cause. I will appoint the Public Defender's Office to represent you. And I will set a bond at $1,000 and all pretrial release conditions. And state, has there been any contact with the alleged victim?
Judge, I have not had any contact with the alleged victim in any case today, so I'm not sure whether we have victims downstairs today or not.
How does it normally work when people?
There has been no contact with the victim.
Okay. Defense, do you have any recommendations on what I should do with regard to contact?
Your Honor, my client doesn't see the alleged victim here, so we would take no position at this point, leave it in the court's discretion.
All right, does your client have a place to live if I order separate residence, or does she live with the alleged victim? It's a brother, I believe, isn't it?
She says she has somewhere else she can go.
Okay, state?
Judge, just sort of across the board, I'll say this a bunch today, but if the victim doesn't come in and say that they want no hostile contact and put on the record sworn testimony about not being afraid, this is the first incident like this, anything like that, then the state's position is no contact and maintain separate residence across the board in DV cases.
I understand some of these unique circumstances, that seems a little harsh, but I will order, ma'am, that you have no contact with the alleged victim until your attorney can, until the alleged victim can be in touch with the state, and until your attorney can file the appropriate paperwork. All right, and it's essentially the document you've signed is what I'm saying. Until your attorney can get the court to modify the order, you're to have no contact with the victim, and you'll need to live somewhere other than the home you were sharing with the alleged victim. Anything else on this case?
Your Honor, may she have a one-time return with law enforcement to collect personal?
Absolutely.
Okay.
One-time return with law enforcement will be ordered.
Thank you.
I'm sorry? All right. She did. All right, and that brings us to Mr. Hatcher.
Mr. Hatcher refused, Your Honor.
Oh, okay. So we'll continue that till tomorrow. So is this Mr. Rios? All right. This is case number 2018 CF 8778. Sir, you have been charged with violation of probation. I've reviewed the affidavit. I find probable cause. I will appoint the public defender's office to represent you, and I'm setting no bond pending further hearing. Oh, the one I wrote. Thank you. All right. All right, this is Mr. Goodman's case, 2019 CF 7117. Sir, you've been charged in this case with grand theft, third degree of a motor vehicle. I've reviewed the affidavit. I find probable cause. I will appoint the public defender to represent you, and I will set a $1,000 bond. Is there anything further to be done on this case? I'm sorry? Something like that. Do I need to do something about those bonds? Have they been revoked? No, I'm asking. I'm sorry. Well, I don't know the status. Counsel, do you know the status of these other cases? I have a notation that there may be some competency issues in the other cases.
Yes.
Have those been adjudications?
I would assume looks like they have court dates of, one case has a court date of July 8th, another of June 20th. My notes show incompetent proceed. I would assume that means that he's been adjudicated incompetent.
Yeah, I don't, and it says status, so I don't know if it's a status post or pre-adjudication. I'm not going to take any action on the bonds in those other cases because I don't know
Thank
what's
you, Judge.
going on in those other cases. So I'm just going to set a $1,000 bond in the current arrest.
Thank you, Judge.
All right, thank you, sir.
Yes.
Thank you.
Thank you, sir. All right, this brings us to Mr. Holland's case. And Mr. Holland's case is, are there 3 cases here? Right, I saw that. Right, okay, so Mr. Holland's cases are 2019 CF 7111. And in that case, sir, you're charged with driving while license suspended with 2 prior convictions. And then also in case number 2019 CF 5402, you are charged with driving while license suspended, 2 prior convictions, and attaching a tag or license plate to an unassigned vehicle. I have reviewed the affidavits. I find probable cause. I appoint the public defender to represent you, and I am not granting a bond in these cases.
Judge,
Yes,
may the
ma'am?
defense be heard? Your Honor,
Yes.
he is entitled to bond on the new cases.
All right, so in case number 2019 CF 7111, I'll set a $2,500 bond. In case number 2019 CF 5402, I will reinstate I'm going to set the bonds at $2,500 for the driving while license suspended, 2 prior conviction, and at $100 for the attaching a tag or license plate to an unassigned vehicle.
Your Honor, may we approach for just a moment on this one?
Sure. It is out of Texas, I thought, wasn't it? Do I need to? That's what we'll do. Thank you. So I'll leave the bonds as announced previously. All right, and then that bring. All right, so then that brings us to Mr. Haverty. Good afternoon, sir. You have been, well, this is case number 1997 CF 1267. Sir, you've been arrested for, I believe it's 8 counts of violation of probation. I've reviewed the affidavit. I find probable cause. I will appoint the public defender to represent you, and I'm not going to set a bond in this case.
It's just,
And he does have reporting requirements once he's released.
I'm sorry?
For the record, he does have reporting requirements once he's released.
Okay.
Your Honor, is this an out-of-county warrant? Okay,
It is an out-of-county warrant.
okay. I don't believe our office would be appointed for an out-of-county warrant.
Okay.
So the, is
So
there any bond on the warrant?
I don't believe so, but no bond. So it looks like, is this, Hernando County. So Hernando County, sir, will be coming to pick you up and you'll appear before a judge there. Thank you. All right, so this is Mr. Reyes Diaz. And this is case number 2019 MM 4206. Sir, you've been charged with possession of cannabis less than 20 grams. I've reviewed the affidavit. I find probable cause. I will appoint the Office of the Public Defender to represent you. And I will grant bond of $250 with all pretrial release conditions. Anything further?
Does the state have an offer to resolve this case?
Yeah, sorry.
I can if you give me just 1 second.
Sure.
Okay.
It's gonna hold him in jail.
There's a hold on?
Conditions before trial. Is that what you're saying? I don't know, ask him, I don't know what you're.
I'm sorry,
Are you saying conditions before trial? That's what you're saying, not PTR supervision?
I was saying subjected to all PTR conditions, but he doesn't qualify at all?
He doesn't have one.
Okay. Well, I will do the $250 bond with the condition of unsupervised drug testing by pretrial release. All right? And they will call you, sir, for those random UAs.
Adjudication court costs.
Your Honor, the state has extended an offer at my client's request of adjudication, time served, and costs.
Okay.
If he'd like to enter a plea and resolve it today.
All right, sir. Has he filled out the form? Thank you. All right, sir. The state has made you a plea offer of credit for time served and cost. Do you wish to plead no contest to the charge of possession of cannabis less than 20 grams?
Yes, sir.
And did you read this document that was handed to me and that I'm holding up?
Yes, sir.
And is this your signature on this document, sir?
Yes, sir.
Are you under the influence of any medications or drugs or alcohol that would affect your ability to understand the rights that you are giving up and the contents of this form?
No, sir.
And do you have any questions about any of the rights that you are giving up?
No, sir.
Do you understand if you're not a U.S. citizen, the entry of this plea would result in your deportation?
Yes, sir.
All right, so I will adjudicate you guilty and impose credit for time served. How many days? 2 days. 2 days with credit for the 2 days served and court costs. And you have the right to appeal within 30 days in writing. The court would appoint an attorney to represent you in that appeal if you wish to appeal and can afford a lawyer.
Thank you, sir.
Thank
Have a
you.
blessed day.
Give me just a second. What I'm doing is looking at their history to just see this. Yeah, yeah, I've got it.
All right, so that brings us to Mr. Trudeau's case. That's 2019 MM 4191. Good afternoon, Mr. Trudeau. You've been charged in this case with trespass on property after warning. I've reviewed the affidavit, find probable cause. I will appoint the Public Defender's Office to represent you. And I am going to stay the bond in the amount previously set, which was $500.
Your Honor, my client's interested in resolving this case today.
Okay?
Your Honor, state would offer an adjudication of guilt, 3 days in the Orange County Jail with whatever credit he has, and no return and court costs.
How many days does he have credit for?
All right. Yeah, I'm sorry?
Today would be my third day.
Okay.
Yes, sir.
Thank you. Sir, is this your signature on this form that has been handed to me?
Yes, Your Honor.
And are you under the influence today of any drugs or medications or alcohol that could affect your ability to understand what you're doing today?
No, sir.
Do you have any questions about the rights that you're giving up, sir?
No, sir.
Are you on probation for any other case?
No, sir.
Do you understand if you're not a U.S. citizen, the entry of this plea would result in your deportation?
Yes.
All right, I'm going to adjudicate you guilty of trespass on a property after warning. I'm going to sentence you to 3 days in the Orange County Jail with credit for 3 days served. And you'll be responsible for court costs. And you have the right to appeal in writing within 30 days of today's date.
Okay,
Right.
sir.
Thank you, sir.
Thank you, Your Honor.
All right, and that brings us to Moreno. I think there may be a typo with your name, sir. Tell me your last name?
Moreno Naboa.
Naboa. All right, there's not a hyphen in here, so I wasn't sure where the hyphen went. Sir, you are charged with violation of probation. This is case number 2018 CF 2647 and 2014 CF 6879. I reviewed the affidavit. I do find probable cause. I will appoint the public defender to represent you. And I am not setting a bond pending further court proceedings. All right, yes, 2018 CF 2647AO. In that case, sir, you are charged with scheme to defraud, less than $20,000, and for fraud, insufficient funds check. And in that case, I will set a bond in the amount of $15,000 on scheme to defraud and $2,500 on the fraud, insufficient funds check. And I do find probable cause, and I appoint the public defender in that case as well. All right, and then this brings us to Mr. Soka. How do you pronounce your name, sir?
That's exactly it, Your Honor.
Soka. All right. One thing I did correctly today. Sir, you are, we are here on case number 19CO564 ALO. You've been charged with soliciting without a permit. Does the state have an offer on this one?
Yes, Your Honor. State would offer an adjudication of guilt, 3 days in the Orange County Jail, with, I'm not sure how much credit he has, and court costs.
Sir, are you interested in taking a plea today?
Yes, sir.
All right. Oh, he is? Or is that? Is that what this yellow thing is? I thought this was the same. Thank you. So I thought this number is the same as this number. How do I know? So I still like what's going on. All right, sir, is this your signature on this plea form that has been given to me?
Yes, sir.
All right, and, sir, are you under the influence of any drugs or medications or alcohol that would affect your ability to understand what's going on in court today?
No, sir.
Do you have any questions about the rights you're giving up today, sir?
No, sir, I understand them.
And are you on probation for any other case?
No, sir.
Do you understand, sir, you do have another case that is open?
Yes. Can I resolve that now?
It does look like it's a county case. State, are we able to resolve that case today as well?
Taking a look right now, Judge. Do you have a case number?
2019-539,
539.
CO 539.
It appears it's set for arraignment June 4th at 1 PM.
I'm sorry, I didn't hear.
It's set for arraignment June 4th at 1 PM.
Yes, Judge, same offer, but to run consecutive, so a total of 6 days.
Not concurrent?
You're out on, well, you've been out on bond on that one, sir, and I could revoke the bond.
I'm
so-
not on bond. It was a written citation, sir.
Oh, okay.
Yes, it was a notice to appear, Judge.
I see. Okay. And you're to return on June 4th. So do you want to resolve both cases or just the one today?
Consecutive or concurrent? Please.
5 days total, Judge. 3 days for the first one, 2 days for the second one, because man, I like him.
And how many days has he been in? Two.
Thank you.
Sure.
All right, so is that what we're doing?
Yes, sir.
All right.
Yes, Judge.
Do we want to add, all right, so can we use one form for both cases? Anyone have an objection with that?
That's fine with me.
All right. Sir, so let's start from the beginning, given that we got off topic. So this is your signature on this form, correct?
Yes, sir.
And it's your desire to enter a no contest plea to case number 19 CO 564 and to case number 19 CO 539. Is that correct?
Correct, sir.
And are you under the influence of any drugs, prescription medications, or alcohol that would affect your ability to understand what's happening in court today?
No, sir.
And do you have any questions about the rights that you're giving up, sir?
No, sir.
And are you on probation for any other case?
No, sir.
You understand that if you're not a U.S. citizen, the entry of this plea would result in your deportation?
Yes, sir.
All right, I am going to adjudicate you guilty in both cases. I'm going to sentence you to 3 days on the first case, that's case number 19 CO 539, to 2 days on the current case, which is 19 CO 564. Those will run consecutively. You'll have credit for 2 days' time served, and you're responsible for court costs, and you have the right to appeal this ruling within 30 days in writing. Notice of appeal has to be filed. The court would appoint a lawyer for you if you wanted to appeal and couldn't afford one, sir.
I understand all that. Thank you.
All right, thank you, sir. Consecutive. All right, and that brings us to Ms. Pareo. Good afternoon, ma'am. This is case number 2019 MM4222. Ma'am, you've been charged in this case with battery, domestic violence. I've reviewed the affidavit. I find probable cause. I don't have, do you have a lawyer, ma'am? I don't have an affidavit. All right, I'll provisionally appoint the Public Defender's Office to represent you. You do have the right to be represented by counsel. If you wish to be represented throughout the case by the Public Defender, you need to fill out an affidavit, all right? I am going to set a bond of $1,000. And I'm going to add the following special conditions. Number one, that you comply with. I'm sorry?
She has a victim.
Oh, thank you. Would you state your name, sir?
Jonathan Bruno Aponte.
And, sir, what's your relationship to the defendant?
We have kids together.
Okay? I'm having a hard time hearing you, sir.
So we have kids together.
That's much better. Thank you. If you can stay close like that. And what is your position, sir, with regard to victim with contact by the defendant?
I honestly just wanted to drop all the charges if that's possible, or whatever that they got going on.
Did you and Ms. Perea live together?
No, we did 2 years back.
And how many children do you have together?
2,
And what are their ages?
4, and 5.
All right, state, what's your position? Or do you have any questions at this point, I should ask?
Yes, Judge. Sir, thanks so much for coming in. Just a couple of quick questions for you. First off, you're not currently living together?
No,
Okay, haven't been living together for a while?
no.
All right. This incident, was it the first one like it, or has there been a history of this in the past?
Minor, not as major.
Okay, nothing major. Is this the first time law enforcement has gotten involved?
Yeah, sort of, but like I said, it wasn't as major as this one, so minor.
Okay, so once or twice in the past, there's been law enforcement involved?
Correct.
Okay. Okay. I don't think I have any other, you're not in fear of her in any way?
No, sir.
Okay. Judge, no concerns with no hostile contact and no concerns with the maintain separate residence provisions at this time?
Defense, do you have any questions for Mr. Bruno?
No questions, Judge.
All right, so I will establish a bond at $1,000. I will order no hostile contact, which means you can communicate with Mr. Bruno as long as there is no hostility in the communication. Maintain a separate residence. Anything further, State?
No, Judge.
All right, anything else, Defense?
No, Your Honor.
All right, thank you.
Your Honor, she does hold separate meetings.
All right, well, I will grant pretrial release with no bond then.
Thank you.
All right, and is this Mr. Gonzalez?
Yes.
Yes, sir. This is case number 2019 CF 7163. Sir, you've been charged in 2 counts. 1, tampering with a witness to hinder communication to a law enforcement officer, and 2, battery domestic violence. I've reviewed the affidavit. I do find probable cause. You are qualified for representation by the Office of the Public Defender, which I will appoint to represent you in this matter. The indication is that there's been no contact from the victim. Is that correct?
That's correct, Your Honor.
So I'm going to order, sir, that you have bonds in the amount of $500 on the tampering with a witness to hinder communication, and $1,000 on battery domestic violence. I'm going to order that you have no contact with the alleged victim, and I'm going to require that you reside in separate residences. And no contact means no contact, as you've been explained in the form that you've signed.
Understood.
All right, thank you. So the next case will be Mr. Hendry.
How you doing, Jan?
Doing well, thank you, sir. Good afternoon. Sir, this is case number 2019 CF 7153. Mr. Hendry, you've been charged with aggravated assault dating violence. Defense, any argument regarding probable cause?
No, Judge.
All right. So I will find probable cause, sir. I will appoint the Public Defender's Office to represent you. Going to order that you have no contact with the alleged victim until the court modifies the no contact order. And I'm going to require that you live in a separate residence. And I'm going to require that you not return to the scene of this incident. And I'm going to grant bond in the amount of $2,500. Anything further? All right, thank you.
Thank you, Jan.
All right, so this is Mr. Rondon?
Oscar Rondon.
Rondon, okay. Sir, this is case number 19 CF 7115. You've been charged, sir, with 3 counts. 1, interference with custody. 2, burglary of an occupied dwelling. 3, violation of a domestic injunction. I've reviewed the affidavit. I find probable cause. You do qualify for representation by the Office of the Public Defender, so I will appoint that office to represent you, sir. I'm going to order no contact with the alleged victim and no contact with the child until these orders are modified by further court order. I'm going to grant you bond, sir, in the following amounts. Count 1, interference with child custody, $2,500. Count 2, burglary of an occupied dwelling, $5,000. And count 3, violation of a domestic injunction, $2,500. So that's a total of $10,000 bond. Is there anything else I need to address on Mr. Rondon's case?
Judge, you didn't mention maintain separate residence. I don't know whether that's necessary in this case or not.
Okay, I will add that. I think you
We don't live
already.
in the same residence, so
Yeah.
she lives somewhere in South Florida. I live in Orlando.
Okay, so you will maintain that status quo then, sir?
No
All
problem,
right.
so I respect that.
Thank you. All right, and then that brings us to Mr. Watson. Good afternoon, sir.
Good afternoon, Honor.
So this is 2019 CF 7145. Sir, you've been charged in this case with aggravated battery with a deadly weapon. I've reviewed the affidavit. I do find probable cause. I see that you are qualified for representation by the Public Defender's Office, so I will appoint the Office of the Public Defender to represent you, and I will set bond at $3,500. All right, anything further? All right, thank you, sir.
Thank you, Your Honor.
Judge, I'm sorry. Were you going to enter a no contact order in this case or no?
Was that a domestic violence? Yeah, I will order a no contact order, sir, until the until the order is modified by further court order, all right? So no contact with the alleged victim.
Right, he's homeless.
Okay. Thank you, sir.
Thank you.
All right, so that brings us to Mr. Colvin.
Yes, sir.
Sir, your case number is 2019 MM 4218. You've been charged with battery domestic violence. I've reviewed the affidavit. I find probable cause. You are qualified to be represented by the Office of the Public Defender, so I appoint the Public Defender Office to represent you. I will set bond at $1,000, and I'm going to order that you have no contact with the victim until further order of the court. And I'm going to order that you maintain separate residence as well. All right, anything further? Thank you, sir. That brings us to Mr. Fincham. Is it Fincham, sir?
Yes, sir.
All right. Sir, your case number is 2019 MM 4214. You're charged with battery domestic violence. I've reviewed the affidavit. I find probable cause. You are qualified to be represented by the Office of the Public Defender, so I will appoint that office to represent you. Set bond at $1,000, and we'll order that you have no contact with the alleged victim, maintain separate residences, and do both of those things until the court modifies its orders. Thank you. All right, sir, I am not going to set a bond. I will release you on pretrial release. You'll be subject to all pretrial release conditions.
Thank you so much.
Thank you.
Thank you.
All right, and that brings us to Mr. Gillis.
Yes, sir.
Good afternoon, sir.
How you doing?
So you are in, your case number, sir, is 2019 MM 4221.
Yes,
You're
sir.
charged with battery domestic violence. I did review the affidavit. I find probable cause. You are qualified, no, you're not qualified for appointment of the Public Defender's Office. Do you have a lawyer, sir?
No, sir.
All right. You intend to retain a lawyer?
Yes, sir. With the Public Defender's Office.
Well, the information I have is that you don't qualify for appointment of the Public Defender because
Why, I make too much?
you make too much.
I just have to hire a lawyer.
So, you don't, the Public Defender's Office, I can provisionally appoint today as friend of the court to
Okay.
assist you, sir, but I'm going to grant a bond in the amount of $1,000.
Yes, sir.
And order that you have no contact with the alleged victim and to maintain a separate residence from the alleged victim until further order of the court.
Okay.
All right?
Yes, sir.
He does? The note I have says he doesn't.
He has an alternate address for the victim.
He has what?
An alternate address on the victim, and it was verified.
Okay, so he does qualify for PTR then. Okay. So I will release you on pretrial release, sir, subject to the conditions of pretrial release.
Okay.
All right? All right, and then that brings us to Ms. Holmes. Good afternoon, ma'am.
Good afternoon.
Ma'am, you're charged in case number 19MM4230 with battery, domestic violence, and violation of PTR conditions on a domestic violence case. And I believe that is going to be case number 2019 MM3948. I do find probable cause. I do find that you are qualified to be represented by the Office of the Public Defender, so I'll appoint them to represent you, ma'am. I'm going to set a $1,000 bond on the battery charge. I'm going to set a $2,500 bond on the violation of PTR condition. And I am going to increase your bond in case number 2019 MM3948 to $2,500.
Just to understand the court, you're revoking that bond and setting a new bond, is that correct?
Yes,
Okay. And that's at what, 2,500?
2,500. Ma'am, you're to have no contact with the alleged victim. You are not to return. You're to maintain a separate residence.
She had one-time return.
Residence, I do. No, he does not live there.
I'm sorry,
My
one,
judge, I thought the alleged victim lived with her. They do not live together.
okay, perfect.
He lived in my business.
All right, any questions?
No, sir.
All right, thank you. That brings us to Mr. or Ms. Ivone. How do you pronounce your name, ma'am?
Yvonne Murillo?
Oh, Murillo is your last name?
Yes, Murillo.
Okay. They've got your names backwards on here, so I apologize for not getting that correctly. Ma'am, your case number is 2019 MM4219. You've been charged with battery domestic violence. I do find probable cause. You're qualified to be represented by the Office of the Public Defender, so I will appoint the Office of the Public Defender to represent you. I will set bond at $1,000. Ma'am, I'm going to order that, you have no contact with the alleged victim, that you maintain a separate residence. Now, is my understanding correct that you and the alleged victim shared a home together?
Yes, sir, it's our home, yeah.
Okay, so until the alleged victim can be in touch with the state and the terms of the order can be modified, I'm going to order that you have no contact, that you live somewhere else, and I will allow you to go one time accompanied by law enforcement to retrieve personal belongings from the residence, all right? And if the alleged victim comes to the state and wishes to have contact, the court will probably modify the terms, all right? Any questions?
No, sir.
All right, thank you. She qualified for PTR, correct? right, and this brings us to Ms. Keen. Good afternoon, ma'am. Your case number is 19MM4231. You're charged in this case with battery, domestic violence, and criminal mischief. I find probable cause. You are qualified for representation by the Office of the Public Defender. I will appoint the Office of the Public Defender to represent you. I'm going to set, ma'am, do you and the alleged victim share a residence? All right, so I am going to set bond in the amount of $1,000 on the battery charge and $250 on the criminal mischief charge. You're to have no contact with the alleged victim and to maintain a separate residence until the order is modified by the court. I would allow you to return one time accompanied by law enforcement to obtain personal belongings.
Your Honor, my client's indicated to me that they have a child in common and she has custody of the child. It's a minor child. Will she be able to get custody of her child back, or what would Your Honor like to do with
Who's
that?
caring for the child now, ma'am? Well, how old's the child?
One.
So who has the child while you're here in jail?
The dad.
Yeah, it's the alleged victim, Judge.
Yeah, that's why I was asking the questions, because no contact. I have no objection to you having custody back, but with the no contact order in place, you cannot contact the alleged victim to obtain custody back. State, any position?
Judge, if she has full custody at this point, that's because there's been a domestic relations judge that has ordered that. She's just gonna have to go through domestic relations court to.
Well, I
to get that
suspect it
straightened
may
out.
be, so have you ever been to family law court to get custody?
This is my first time here.
But when you, so are you married to the father of your child? And has there ever been a paternity action, or is he identified on the child's birth certificate?
He is on the birth certificate. They have not gone to court regarding custody arrangement.
Okay, so it's a de facto, custody, which is what I was guessing, but, so again, ma'am, unless there is an official court order granting you sole custody, you don't necessarily have rights to the exclusion of the alleged victim. You're not allowed to communicate with the alleged victim. State, do you have an objection to me allowing communication with regard to the child, or?
I do, Judge. There are other ways to accomplish that through law enforcement or through counsel that wouldn't involve her violating a no-contact order. Certainly, defense can file a motion to modify that no-contact order, and the typical way to do that is to appoint some third party to handle custody issues that both of them can live with. That avoids
All
any
right.
issues of harassment or tampering or anything like that.
So if I heard you correctly, you don't have, you won't take the position that if counsel contacts the alleged victim with regard to child care, that will not be a violation of the no contact order by a third party?
The state would not have any concerns with that.
Okay, that was my concern about that, but okay. So, ma'am, your attorneys can maybe help facilitate communication with the alleged victim to get the situation back on track. All right, thank you. And then this brings us to Mr. Brand's cases. Good afternoon, Mr. Brand. I have two cases for you. 2019 CF 6948. That case has 5 counts. Felony battery. Count 2, battery, domestic violence. Count 3, false imprisonment. Count 4, child abuse. And count 5, assault, domestic violence. I have reviewed the affidavit. I find probable cause. You're qualified for appointment of the Office of the Public Defender, so I'll appoint the public defender to represent you in that case. And I will set bond in this case in the amount of ROR on felony battery, $1,000 on battery domestic violence. That's count 2. Count 3, false imprisonment, $3,000. Count 4, child abuse, $1,000. And count 5, assault, domestic violence, $1,000. Case number 2019 CF 1034. You're charged in that case with possession of methamphetamine and possession of drug paraphernalia. No, that's the underlying charge. You're charged with failure to appear is what you were arrested for. So you failed to appear in the case in which you're charged with possession of methamphetamine and possession of drug paraphernalia. There are no bonds, and I'm going to stay those amounts.
Judge, in 19 CF 6948, were there any other conditions?
Yes, yes, thank you. In that case, there will be no contact with the alleged victim, maintain separate residence. If you shared a residence, I will allow you to go one time with law enforcement to obtain personal belongings. Thank you. All right, and that's all I have in front of me at the moment. If you all have not had your lunch break, please go and have it while I finish reading.
Thank you, Judge. When would you like us back?
$4:30.
4:30?
Yeah.
Okay.
I'll go as fast as I can. I apologize. I apparently read too much. So all I can say is thank you. All right, good afternoon, everyone. We're back on the record, and we will begin with Mr. Baker. And that is case number 2019 CF 7130. Mr. Baker, you're charged with possession of cannabis less than 20 grams and possession of cocaine. Is there any probable cause challenge? I'll find. Any probable cause challenge?
No, Judge.
I'll find probable cause. Sir, you're entitled to be represented by the Office of the Public Defender. I'll appoint the public defender, and bond will be at $100 on count 1, possession of cannabis, and $1,000 on count 2, possession of cocaine. Anything further?
violation of Pearl listed as well.
Well, there is on the PTR, but it's not on the,
It won't be heard in IEs.
it's not heard in IAs, yeah, so.
You have $1,000 in the. I don't know. You'll have to ask her.
This one. Hello.
All right, and then we have Mr. Boyd's case, and that is case number 2019 CF 7140. Mr. Boyd, you are charged in count 1 with possession of cocaine and in count 2 with possession of drug paraphernalia. Any probable cause challenge?
No, Judge.
And so we will find probable cause. Sir, you qualify for the Public Defender's Office representation, so I will appoint that office to represent you. And I will set bond on count 1 at $1,000 and count 2 at $100. Thank you. And this is Mr., is it Brady or Brady?
Brady.
Brady, okay, sir, thank you. Mr. Brady's case is 2019 CF 7101. Sir, you're charged with burglary of a structure. You do qualify for representation by the Office of Public Defender, so I will appoint that office to represent you. And is there a probable cause challenge?
No, Judge.
So the court will find probable cause and will set bond. There is no bond, okay, $3,500.
He does qualify for PCRA.
Okay, so I will, oh, that's not working.
Is there a bond being set, sir?
I'm going to release you on pretrial release terms. There will be no bond, other than the pretrial release terms. And you'll be subjected to all of those terms, sir.
He has a hold for Volusia County that he has to satisfy.
He has what?
A hold for Volusia County that he has to satisfy.
Okay. But in this case, you'll be released subjected to the pretrial release terms.
Does that mean he has to wait till Volusia?
It has a bond of 75.
All right, next is Mr. Collins' case. That's case number 2019 CF 7132. Is there any probable cause challenge in this case?
No, Judge.
So, sir, you're charged with possession of a firearm by a convicted delinquent in count 1. Count 2 is possession of ammunition by a convicted delinquent. Count 3 is grand theft in the 3rd degree with a firearm. And count 4 is possession of a controlled substance. You qualify for representation by the Public Defender's Office, so I will find probable cause and will appoint the Public Defender to represent you. I'm going to set bond on count 1 in the amount of $5,000. Bond on count 2 in the amount of $150. Bond on count 3 in the amount of $150, and bond on count 4 in the amount of $150. All right. And this is another, sir, would you state your name for the record?
Huh?
Would you say your name for the record, please?
Kelvis Dario Contreras.
Contrada, okay. Your name is run together on the documents that I have.
they're put
so-
together, yeah.
So, sir, you are, your case number is 2019 CF 7122. In that case, you are charged with grand theft in the 3rd degree. greater than $300 and less than $5,000. You qualify for appointment of the Public Defender's Office. Is there a challenge to probable cause in this case?
No, Judge.
So I will find probable cause and will appoint the Public Defender's Office to represent you in this case. You also have case number 2019 CF 5644, sir, on
Yes,
which
sir.
you were out on bond for a similar charge. So in the current case, the new case, 7122, I'm going to set a bond of $2,500. And I am going to revoke your bond in case number 2019 CF 5644, and that will have to be set before the judge in that case to determine what bond amount, if any, would be granted.
And, Your Honor, can you have a public defender's office appointed to that case? It didn't appear that we had been previously appointed.
I can, yes, I will appoint the Public Defender's Office to represent you in that other case, sir. Thank you. All right, you're Mr. Cummings?
Yes, sir.
Thank you. All right, so Mr. Cummings, in your case is number 2019 CF 7105. So you're charged with burglary of a conveyance in count 1, count 2, grand theft in the 3rd degree, greater than 300, less than 5,000, and count 3 is fraudulent use of credit cards. Any probable cause challenge?
No, Judge.
I will find probable cause, sir. You're entitled to representation. You qualify for representation by the Public Defender's Office, so I will appoint that office to represent you in this case. And I will set bond on count 1 in the amount of $3,500, count 2 in the amount of $150, and count 3 in the amount of $150.
Thank you.
Thank you, sir. All right, and this is Mr. Ferris. Good afternoon, Mr. Ferris. Your case number is 2019 CF 7121. Your case, sir, your 4 counts. Count 1, possession of methamphetamine. Count 2, possession of drug paraphernalia. Count 3, possession of heroin. Count 4, possession of cannabis. Is there a probable cause challenge in this case?
I had made a note that there may be a probable cause issue on the possession of heroin. I don't have the affidavit in front of me, though.
Okay.
Your Honor, Matt Kazera for the state. The probable cause affidavit at the end of it indicates that he had I believe a bag of what was tested with a presumptive field test for the presence of heroin, and it came back presumptive positive, which is sufficient for probable cause.
The entire affidavit seemed a little conclusory. It didn't really have much as far as a factual basis. I think it just said he had all these things.
Yeah.
Judge, I don't know that it would survive a motion to suppress with this, but the judge, or the officer noted that he had these substances on his person.
Yeah, I will find probable cause. I will set bond in the amount of, and you do qualify for representation by the Office of the Public Defender, sir. So I'll appoint that office. You are entitled to bond in the amount of $1,000. I'll set bond in the amount of $1,000 on count 1, $500 on count 2, $1,000 on count 3, and $250 on count 4. Thank you, sir. All right, Mr. Gaines. Good afternoon, sir. Your case number, sir, is 2019 CF 7143. You qualify for representation by the Office of the Public Defender, so I will appoint that office to represent you. Is there any challenge to probable cause in this case?
No, Judge.
All right, so I'll find probable cause and I will set bond. Sir, you're charged with count 1, burglary of a dwelling, count 2, aggravated assault with a deadly weapon, count 3, resisting officer without violence, count 4, criminal mischief. I'm going to set bond in the amount of $5,000 on count 1. I'm going to set bond at $2,500 on count 2. On count 3, $150, and on count 4, $100. Thank you, sir. All right, and then we have Mr. Grace. Sir, you're here on a couple of cases. The new case is 2019 CF 7102. You're qualified to be represented by the Office of the Public Defender, so I will appoint that office to represent you. Is there a challenge to probable cause?
No, Judge.
All right, so I will find probable cause on the new case and set bond. I'll set bond on count 1, burglary of a structure at $3,500. I will set bond on count 2, criminal mischief at $150. So you're also have an ongoing case in 2018 CF 17132 and which is consolidated with 2018 CT 2445. And you had bond in that case. I'm going to revoke the bond in those consolidated cases and allow that to go back before the assigned judge to determine what appropriate bond amount would be in that case. That brings us to Mr. Green. So your case number is 2019-7141. You qualify to be represented by the Office of the Public Defender, so I will appoint that office. Is there any challenge to probable cause in this case?
No, Judge.
All right, I'll find probable cause, sir. You're charged with 3 counts, possession of MDMA or ecstasy. Count 2, possession of cocaine, and count 3, possession of drug paraphernalia. I will set bond at $1,000 on count 1, $150 on count 2, $100 on count 3. Anything further?
No, Judge.
Okay, thank you. And that brings us to Mr. Green. Sir, you are qualified to be represented by the Office of the Public Defender, so I will appoint that office to represent you. Counsel, is there any challenge to probable cause in Mr. Green's case?
No, Judge, but it does appear he qualifies for pretrial release.
Yeah, I see that. Thank you. So, sir, you're charged in this case with possession of controlled substance without a prescription. So because you are qualified for pretrial release, I'm going to grant pretrial release subject to all those terms. All right? All right, thank you. And then we have Mr. Harbor. Sir, your case number, we have a couple of cases here, but the new case is 2019 CF 7126. You qualify for representation by the Office of the Public Defender, so I will appoint that office to represent you. Counsel, any probable cause challenge in this case?
No, Judge.
All right, so I'll find probable cause. Sir, in this case, you're charged with one count, grand theft in the third degree of a motor vehicle. I am going to set bond in this new case at $2,500. You're also have a return date in case number 2019 CF 1374. The paperwork doesn't indicate if there's a bond in that case. Do we know? He's on pretrial release. So I'm going to revoke pretrial release and set zero bond and let the judge in that case determine an appropriate bond. All right, the next case is Mr. Jones. Good afternoon, sir. Case number 2019 CF 4288. Sir, in that case, you do qualify for well, I don't have an affidavit, I don't think. Yes, I don't have an affidavit, so, sir, you're right, you have another case, case number 2019 CF 448. Do you have a public defender in that case?
Yes.
He does, Your Honor. I
Okay.
identified that.
So I'll appoint the public defender's office in this case as well then. Is there any probable cause challenge in this case?
No, Judge.
All right, sir, you're charged with 2 counts, failure to report, vacating a residence within 48 hours, and the failure to report name of residence change. So in that case, I'm going to set a bond of $1,000 on count 1 and a bond of $100 on count 2. With regard to your other case, 2019 CF 44880, you're out on bond of $2,500 on that case. I'm going to revoke that bond and allow the judge in that case to determine an appropriate bond. Mr. Murrow, you're here on case number 2019 CF 7127. You do qualify for representation by the public defender, so I'll appoint that office to represent you in this case. 2 charges, count 1, possession of cocaine, and count 2, possession of drug paraphernalia. I am going to set bond on count 1 in the amount of $2,500 and on count 2 in the amount of $100. And you also have another court case, 2019 CF 5904. You're out on bond in the amount of $1,000 there. I'm going to revoke that bond and allow that bond to be determined at a later date by the judge assigned to that case.
Your Honor, I don't believe in this case you appointed the public defender or discussed probable cause.
The case I just talked about?
Yeah, this case.
This case I did.
Oh, 7127? Did I just miss it? Sorry.
Yeah, you did. You did. That's one thing I did right today.
He already has a public defender.
And he
on
already
the
has a
other-
public defender in the
Yes,
other
Judge.
case, Mr. Goff, yes. Actually, the other case, sir, do you know, are you in front of me in the other case?
No,
You're not, or you don't know?
I don't know.
I think you are, yeah, Division 14, you are in front of me. So what I'm gonna do, I'm going to revoke the $1,000 bond, and I'll set that at $2,500 in the case with Mr. Goff. I'm sorry? Yes. That'll save Mr. Goff from having to file another motion.
Thank you, Judge.
All right, and then is this Mr. McNeil?
Yes, sir.
Sir, your case number 2019 CF 7106, and I'm not sure I found probable cause on Mr. Marrero's. Okay. All right, Mr. McNeil is 2019 CF 7106. Sir, you qualify for appointment of the Office of the Public Defender to represent you, so I will appoint that office to represent you. Counsel, is there any probable cause challenge in this case?
No, Judge.
So I will find probable cause, and, sir, you're charged with 2 counts, burglary of a conveyance in count 1, count 2, grand theft in the 3rd degree, greater than 300, less than 5,000. I will set bond in the amount of $3,500 on count 1 and $150 on count 2. Thank you, sir. Anything further? All right, and this is Mr. Perez Luca, case number 2019 CF.
No, that's not me.
That's not you? Who are you, sir?
Roller.
Roller. All right. Is Mr. Perez Luca in the courtroom? I wonder if something happened to him.
Probably bonded 1901-5093.
Okay, perfect. Mr. Roller, sorry about that, sir. 2019 CF 7032. Sir, you qualify for a representation by the Office of the Public Defender. I'll appoint that office to represent you. Counsel, is there any probable cause challenge in this case?
No, Judge, it was a warrant arrest.
So, probable cause previously been determined. And, sir, you're charged in this case with grand theft in the 3rd degree. I will set a bond of $2,500. Or impose the bond that was previously set at $2,500. Thank you, sir. All right, Mr. Simmons. All right. All right, the public defender was previously appointed on this case. And this is case number 2018 CF 16577AO. And this is on a capias for failure to appear at a hearing on April 12th, 2019. I'm not going to set a bond, and I will allow that bond to be determined at a future hearing in front of the judge presiding on this case. I'm sorry? He has another case there? Okay, and here's also 2016 CF 15731. There's a capias on that also for failure to appear at a hearing on April 12th. So, and a capias was issued, so I will not set a bond on that case either. Will allow the presiding judge to deal with it and set an appropriate release term. All right, Mr. Thomas, good afternoon, sir. Case number 2019 CF 7113. Sir, you qualify for representation by the Office of the Public Defender, so I will appoint that office to represent you. Any challenge to probable cause, counsel?
No, Judge.
And I will find probable cause. Sir, you're charged with 2 counts, grand theft the 3rd degree of the motor vehicle, and count 2, possession of fentanyl. I'm going to set bond on each count at $2,500. All right. Mr. Tomingo, how do you pronounce your name, sir? Tell me how you pronounce your name, sir.
Domingo.
Tomingo?
Yes, sir.
All right, thank you, sir. Your case number is 2019 CF 7147. Sir, you are qualified to be represented by the Office of the Public Defender, so I will appoint that office to represent you. Counsel, any probable cause issues?
No, Judge, but it appears he qualifies for pretrial release.
Okay, thank you for pointing that out. I'm going to find probable cause. Sir, you're charged with 2 counts. Count 1 is possession of MDMA ecstasy, and count 2, possession of drug paraphernalia. I will release you, I will order release on pretrial release, all terms. And anything further? Okay.
Thank you.
Thank you.
Thank you, sir.
All right, this is Mr. Ware.
Yes.
Good afternoon, sir.
How you doing?
2019 CF 7137. Sir, you're charged with 6 counts in this case. You are entitled to be qualified to be represented by the Public Defender's Office. I will appoint that office to represent you. Is there any issue with probable cause in this case?
No, Judge.
All right, sir, the 6 counts, you're charged with possession of cocaine with intent to sell and deliver, possession of, count 2, possession of ammunition by convicted felon, count 3, possession of cannabis with intent to sell or deliver, count 4, possession of Xanax, count 5, possession of oxycodone, and count 6, possession of drug paraphernalia. You do not qualify for pretrial release, so I'll set bond in the following terms. Count 1, $15,000. Count 2, $150. Well, count 2, 3, 4, and 5, $150 each, and count 6, $100. Right? Thanks, sir. Good afternoon, sir. You're Mr. Weaver?
Yes, sir.
Excellent. Mr. Weaver, your case number is 2019 CF 7107. You qualify for appointment of the Office of the Public Defender, so I will appoint that office to represent you. Is there any issue, counsel, with probable cause?
No, Judge.
Sir, you're charged with 3 counts. First count, burglary of a structure. Second count, ground theft in the 3rd degree, more than 300 and less than 5,000. And count 3, dealing in stolen property. You do not qualify for pretrial release, so I'll set bond in the amount of $3,500 for count one, $150 for count two, and $150 for count three. Thank you, sir. And you're Mr. Wilbon?
Yes, sir.
Did I get the name right?
Yeah, Wilbon. Yeah.
Wilbon, okay, great, thank you, sir. So your case number is 2019 CF 7116. In that case, sir, you're qualified to be represented by the Office of the Public Defender, so I will appoint that office. Counsel, any issue with probable cause?
No, Judge.
I will find probable cause and appoint the Office of Public Defender to represent you, sir. The count you're charged with in this case is possession of cannabis with intent to sell and deliver. I'm going to impose a bond of $2,500 on that count. You're also involved in case number 2019 CF 6663. Where you're out on bond in $1,000. I'm going to revoke that bond and allow the judge in Division 19 to determine an appropriate bond at a future hearing.
Your Honor, could you appoint the Public Defender's Office on that case as well?
Absolutely.
I don't show that we were previously appointed.
Sure, absolutely. So I'll appoint the Public Defender's Office for 2019 CF 6663 as well. Thank you, sir. Okay, and you're Mr. Wilcher?
Yes, sir.
All right. Good afternoon, Mr. Wilcher. Your case number is 2019 CF 7131. Looks like you qualify for pretrial release. You also qualify for appointment of the Public Defender's Office, so I'll appoint that office to represent you, sir. Are there any issues, counsel, with probable cause?
No, Judge, but as you pointed out, he qualifies for straight pretrial release.
Yes. So, sir, you're charged with 2 counts. Number 1, driving while license suspended with 2 prior convictions, and count 2, possession of cannabis less than 20 grams. Because you qualify for pretrial release, I will order pretrial release subject to all those terms. All right? Thank you, sir. And you're Mr. Wilkins?
Yes, sir.
All right, Mr. Wilkins, your case number, got a couple here, but your case number that we're here for today is 2019 CF 7133. In that case, sir, you do qualify for representation by the Office of the Public Defender. So I'll appoint the Public Defender to represent you in this case. You're charged with possession of MDMA and or ecstasy. You do not qualify for pretrial release. Is there any issue with probable cause, counsel?
No, Judge.
So I am going to set a bond of $2,500 on this case. Sir, you also have case number 2019-6234. You're out on bond on $1,000. That's in Division 16. Looks like the public defender is appointed in that case. Is that correct? So I'm going to revoke this bond and allow the judge in Division 16 to decide what an appropriate bond would be at a future court hearing.
Okay.
All right. Thank you, sir. And, sir, are you Mr. Johnson? No, Mr. Hall.
Mr. Worrell, sir.
All right, so we have another case that may have, you're Mr. Wilson?
Worrell.
Worrell, okay. So did Mr. Hall bond out case number 2019 CF 7134? Inmate number, we'll find it faster than me.
1901-5052.
All right. Thank you. Thank you. All right, Mr. Worrell, you qualify for for representation by the Office of the Public Defender, so I will appoint the public defender to represent you in this case, sir. Counsel, any issue with probable cause?
No, Judge.
Sir, you're charged in this case with 2 counts. Count 1, possession of cocaine, and count 2, possession of drug paraphernalia. You do not qualify for pretrial release, so I'm going to set a bond in the amount of $1,000 on count 1 and a bond of $100 on count 2. And if I didn't say I find probable cause, I find probable cause. Thank you, sir. All right, and is this Ms. Vandersloot?
Yes, sir.
All right, did I get the name correctly?
Yes, sir.
All right. All right, ma'am. This is in case number 2019 MM2230. And you were arrested on a capias for failure to appear at a pretrial conference on May 9th. So I am not going to set a bond, and I will allow the judge, in that case, to determine how best to proceed. It's the bonds for the, was she out on, was the defendant out on pretrial release before?
I think she may have just posted a bond.
She may what?
May have just posted a bond.
That's what I mean, it looks to me like she posted a bond and failed to appear, and that's why I was, not setting a bond in this case. Counsel, approach, please. All right, so I am going to, I'll rescind the no bond, and I'm going to, based on review of the document at sidebar, I'm going to, can't really tell what these amounts are, but I'll double them. on the assumption that these were the original bond amounts. So on count one, the bond will be $4,000. On count two, the bond will be $200. And on count three, the bond will be $200. All right. Mr. Prescott,
Yes, sir.
did I get the name halfway correct?
Huh?
Was I close with your name, sir?
It's there. They
How do you
say
pronounce it?
Prescott, like Prescott.
Prescott.
Si.
Okay. All right, sir. You are qualified to be represented by the Office of the Public Defender, so I will appoint the Office of the Public Defender to represent you in this case. This case is case number 2019 MM 4217. Counsel, any issues with probable cause?
No, Judge.
All right, sir, count one is resisting an officer without violence, and count two is possession of cannabis less than 20 grams. So in this case, I'm going to set bond on count one at $500 and on count two at $250. You're also having a case 2019 CF 6252 in division number 19. You're out on bond in the amount of $1,000. So in that case, I'm going to revoke the bond and allow the judge in division 19 to decide what an appropriate bond would be in light of the new case.
Have we been appointed to that case?
Can't tell, so I'll appoint you.
Okay.
Yeah, thank you. I'm sorry? Is there a third case? Hold on, there may be a third case. Oh, this? Oh, yes, okay, here is another case, 19 CT 3764. Driving while license suspended. And, counsel, did you see any probable cause issues with that case?
No, Judge.
On that case, I'll set a bond at $500 and find probable cause. All right, thank you, sir. I'm sorry? 500, yeah. All right, Mr. Solis. All right, Mr. Solis, you do apparently, well, that looks to be inconsistent. Okay. All right, so you are qualified to be represented by the Office of the Public Defender, so I will appoint that office to represent you in this case. Counsel, do you see any issues with probable cause?
No, Judge.
All right, sir, and you're charged with one count of moving traffic violation, driving while license suspended, first offense. You do not qualify for pretrial release, so I'll set a bond. I'll find probable cause and set a bond at $500. There is also a probation violation for a Volusia County case number 180305. Is there a hold for Volusia? Okay. So, sir, there's no bond on that, so, at some point you'll be transported to Volusia County and, appear before a judge there on the probation violation. All right, and Mr. Biles,
Yes,
Biles
sir.
Johnson, or?
Yes, sir. Chance Biles.
Kenneth Biles, so you, okay. Sir, case number 2019 MM4213. I don't have an application for the public defender. Did you complete one?
No, I didn't.
Okay, so do you intend to hire private counsel?
No, I'm fine.
What do you mean you're fine?
I don't intend to hire one.
Okay, well, you're entitled to counsel, sir. I'll appoint the public defender as friend of the court today.
Okay.
You can complete an affidavit later, or hire private counsel, or if you desire to represent yourself, another court will have a more thorough conversation with you about that.
Okay.
Sir, you're charged with one count of trespass on property after warning.
Yes.
I will find probable cause. You do not qualify for pretrial release, so I'll set a bond on that at $500. All right? Thank you, sir. Are you Mr. Anderson?
Yes, sir.
All right. The names are backward on Mr. Anderson's. So this is case number 2019 MM4224. You are qualified to be represented by the Office of the Public Defender, so I'll appoint that office to represent you in this case, sir. Counsel, did you find any probable cause issue?
No, Judge.
All right, so, sir, you're charged with one count of battery in this case. You do not qualify for PTR, so I will set a bond in the amount of $500.
Is there a way we can lower it so I can get out? Or, because I can't afford $500 right now, and I have nobody to bond me out.
You have no one to bond you out.
No, I have no phone numbers or anything to call anybody. But if I can do like $200, $250 or something like that, I have enough in my bank account, I can do it myself. I mean, I haven't been arrested in a long time, so.
Okay, yes.
Matt Kazera for the state. I'm not entirely sure. I don't have his rap sheet or anything here, but I do have from Department of Corrections an indication that this may be his third battery, just to take into consideration. I don't know why law enforcement only arrested him for the battery instead of the one prior felony offense.
Because the other ones got dropped. Oh, sorry.
Judge, it does show he's below average in the risk assessment.
And one final note, Judge, regardless of what amount we end up setting, I would ask that there be a no contact order that's put in place as well.
All right, I'll also order no contact with the victim. Sir, I'm gonna leave it at 500 and let the public defender file a motion, in front of the judge it'll be assigned to.
Okay,
All right, thank you.
thank you.
All right, and are you Ms. Fondario?
Yes, sir.
All right. So the case that brings us here today is case number 2019 MM4225. Ma'am, you do qualify for representation by the Office of the Public Defender, so I will appoint that office to represent you. Any issue with probable cause? Counsel, any issue with probable cause? Okay, I'm sorry, I'm not hearing very well up here. All right, so I've appointed the Office of Public Defender. I'll find probable cause. Ma'am, you're charged with one count of possession of drug paraphernalia in this case. So I will set bond on this case at $500. You also have two other cases. Case number 2019 CF 2002 and case number 2019 CF 2001. You're out on bond in those cases. I'm going to revoke those bonds and allow those matters to be set in front of the judges in those cases.
Judge,
In light of-
she may have been out on like a 33-day motion on both cases, and it doesn't look like the state's picked up either case. So
Okay.
If you wanted to revoke the release, we'd ask that you set a bond, and
How are you seeing that? What are you seeing that shows that?
I'm basing it on what my client's telling me. She's saying she's not out on bond, she was out on a release.
Because what I'm looking at shows a bond amount. How can we? On both of them? All right, so I will set a bond in case number 2019-2002 in the amount of $5,000 and 2019 CF 2001 in the amount of $3,500. And we'll revoke the ROR in those cases. All right, thank you, ma'am. All right, is this Mr. Galloway? Sir, your case is number 2019 MM4208. You do qualify for representation by the Office of the Public Defender, so I'll appoint that office. You're charged, sir, with one count of possession of drug paraphernalia. Counsel, any issue with probable cause?
No issue with probable cause. He is interested in resolving his case this afternoon.
All right.
Offer from the state would be an adjudication and credit for time served, Judge.
How many days does he have? All right. Sir, are you under the influence of any prescription medications, drugs, or alcohol that would influence your or affect your ability to understand what's going on today?
Yes, sir. I'm not under the influence, sir.
Okay. You're not taking any medication or
No,
anything?
sir.
All right. And, sir, do you have any questions about the rights you're giving up by entering this plea?
Yes, yes, sir.
No, do you have any questions about the
Oh,
right
no,
you're
no, no,
giving up?
no, sir.
All
No,
right.
sir.
And is this your signature on the form, sir?
Yes, sir.
You understand the entry of this plea would result in deportation if you're not a U.S. citizen?
Yes, sir.
And are you on probation in any other case?
No, no, sir.
All right, and did you read this form before you signed it?
Yes, sir.
All right. I'm going to adjudicate you guilty, give you credit. I'm going to impose 2 days in the Orange County Jail, credit 2 days time served, court costs. You'll be responsible for those. What do you put, a year on those? You'll be responsible for paying those within a year. And you have a right to appeal. You have to file a written notice of appeal within 30 days of today's date.
Thank
All right,
you.
sir? Thank you, sir.
Judge, I think you may have forgot to ask him which he pled guilty or no contest. He wants to plead no contest.
Oh, yes. You plead no contest, sir?
Yes, sir.
All
Yes,
right,
sir.
thank you. Now, who was that? All right. Mr. Jackson. All right, sir, your case is 2019 MM 4204. You qualify to be represented by the Office of the Public Defender, so I'll appoint that office. You're charged, sir, with trespass on property after a warning. Counsel, did you see any issue with probable cause?
No, Judge.
Sir, you do not qualify for PTR, so I will find probable cause and impose a bond of $500. Thanks, sir. And that brings us to Mr. Rivera. Sir, your case number is 2019 MM 4205. You are charged with, I pronounce it petit, some people pronounce it petty, theft, prior theft convictions. You're qualified for representation by the Office of the Public Defender, so I will appoint that office. Counsel, any issue with probable cause?
No, Judge.
Sir, you do not qualify for pretrial release, so I will impose a bond amount of $500. Thank you, sir. All right, let's have Mr. Roberts. Good afternoon, sir.
How you doing now? I mean, sir.
2019 MM 328. Sir, you qualify to be represented by the Office of the Public Defender, so I will appoint that office to represent you. You're charged, sir, with 1 count possession of drug paraphernalia. You do not qualify for pretrial release. Counsel, did you see any probable cause issues?
No, Your Honor, but my client is interested in an offer to resolve it today.
Okay.
Offers an adjudication, credit time served, and court costs.
How many days? 1 day.
1 day?
Sure, he'll be pleading no contest.
Thank you. All right, sir. I have a form here that indicates you wish to plead no contest to the charge of possession of drug paraphernalia. Is that what you wish to do, sir?
Yes, sir.
All right. Are you under the influence of any medication or drugs or alcohol that would affect your ability to understand what's going on today?
No, sir.
And do you have any questions about the rights you're giving up by entering this plea, sir?
No, sir.
Are you on probation on any other case?
No, sir.
Did you have enough time to review and understand this form before you signed it?
Yes, sir.
And is this your signature on this form, sir?
Yes, sir.
All right, I am going to adjudicate you guilty of the charge of, or the offense of possession of drug paraphernalia. Sent you to 1 day in the Orange County Jail with credit for time served. So you're going to be responsible for court costs. Those will be due within 1 year. And you have a right to appeal. You need to file, to appeal, you have to file a notice of appeal in writing within 30 days. Thank you, sir. Are you Mr. Ranch?
Yes, Your Honor.
Okay, good afternoon, Mr. Ranch. We're here on 2019 2019 MM 4216. Sir, you qualify to be represented by the Office of the Public Defender, so I will appoint the office in that case. You're also here on case number 19 MO961, and I will appoint the public defender in that case as well, sir. In the misdemeanor case, you are charged with possession of cannabis less than 20 grams. Counsel, any probable cause issue with that charge?
No, Judge.
And in the misdemeanor case, or the municipal ordinance case, rather, you're charged with violation of state misdemeanors in lieu of a statutory offense for possession of a dairy crate. Any probable cause issues with that, counsel?
Your Honor, no probable cause challenges, however, he is interested in resolving it today.
Both cases? All right.
Both cases would be an adjudication, credit time served, and court costs.
No.
Still 2 years suspension.
Your Honor, he'll be entering a no contest plea.
Okay, thank you. Mr. Ranch, I'm being handed a form. Did you sign this form, sir?
Yes, sir.
Did you have ample time to read and understand the form?
Yes.
Did you read the form?
Yes, Your Honor.
Okay, and my understanding is you wish to plead no contest to the charges that I just reviewed with you, which were possession of cannabis and violation of state misdemeanors in case numbers 19 MM 4216 and 19 MO 961. Is that what you wish to do, plead no contest in both of those cases?
Yes, Your Honor.
All right. Are you under the influence of any medication, drugs, or alcohol that would affect your ability to understand what you're doing today?
No, Your Honor.
And do you have any questions about the rights that you're giving up, sir?
No, Your
Are
Honor.
you on probation in any other case?
No.
Do you understand if you are not a U.S. citizen, entry of this plea would result in deportation?
Yes, Your Honor.
All right, I will accept your plea. I will sentence you to, how many days was it, 1 day? 2 days. I'll sentence you to 2 days in the Orange County Jail with credit for 2 days' time served. Sir, you're responsible for court costs. Those will be due within 1 year. And you have a right to appeal. Notice of appeal has to be in writing and filed within 30 days of today's date.
Okay. Yes, Your Honor.
Thank you, sir. Good luck to you.
All right.
Started writing court costs instead of my name. Mr. Hayward?
I'm Miss.
Miss Hayward, I'm sorry. My apologies. All right, ma'am, your case is 19 CT 100. And it is an out-of-county warrant from Lake County. And there is a bond in the amount of $50,000. So you can post that bond, or you'll be transferred to Lake County and appear before a judge there. All right? All right, and are you Mr. Melgar?
Yes, sir.
Is that how you pronounce your name?
Sorry?
How do you pronounce your name, Melgar or Melgar?
Melgar.
Melgar, all right. Sir, your case number is a Polk County case number 27741. There is a, is this a capias? Or a warrant? Yeah, there's a warrant for failure to appear in Polk County. And the bonds on that, sir, are $2,000 on count 1 for failure to appear and $2,000 on count 2 for failure to appear. If you do not bond out, you'll be transferred to Polk County and appear before a judge there. All right?
Okay.
Thank you, sir. All right, and you are Mr. Schenk?
Shank, yes, Your
Shank,
Honor.
okay. Mr. Shank, you're here on a Broward County warrant, case number 19004605 CF 10A. Sir, there are 4 out-of-county warrants. They total $9,000. First count is $3,500, second count is $3,500, counts 3 and 4 are $1,000 each. So you will post that bond, or you'll be transferred to Broward and appear before a judge there. All
Yes,
right?
Your Honor.
Thank you, sir. And Ms. Reynolds. No, I have Mr. Reynolds. So are you Ms. Jones?
Yes, sir.
Okay, so did Mr. Reynolds bond out? Or did he refuse? He refused to come up yesterday. Did he refuse again? He refused again? So do I need to render an order to have him brought tomorrow? Is that the standard procedure?
Your Honor, you can reset it again, or you could just have us appointed and find probable cause and set a bond. And
Okay.
consider his appearance waived.
Well, I don't have an affidavit. So I will, I'll continue this to tomorrow for Mr. Reynolds' case, and what I do downtown is I issue an order to have the defendant brought by whatever means are necessary when they refuse to come to court, and since he's done this twice, that's what I want to do. He needs to show up and either do an affidavit or do whatever. All right, Ms. Jones, case number 2017 CF 4070. Ma'am, you're here on a violation of probation. You've been charged with violating conditions 2, 5, and 10. There are 2 counts on condition number 5. You are qualified to be represented by the Office of the Public Defender, so I will appoint the Office of the Public Defender to represent you in this case. Probable cause has previously been found, so I'll find probable cause. And, ma'am, you'll be held on no bond until you can appear before the judge who's presiding over this case. And Mr. Oliveras? Good evening, sir.
Yes, sir.
So, sir, we have a couple of cases today. First of all, you're entitled or you're qualified to be represented by the Office of the Public Defender. So I will appoint the office to represent you today in this case. And this case is 2018 CF 3895. And it is a violation of probation. Probable cause has previously been found on that. I will find probable cause and order no bond until you can appear before the judge presiding on that case. You also, sir, have case number 2019 CF 6688 in Division 15. And it appears you're out on a $1,250 bond. I am going to revoke that bond until you can appear back before the judge in Division 15 to determine an appropriate bond in light of the
Would that be?
the circumstances.
How long would that be before my next court date?
Well, you'll have two court dates. You'll have the violation of probation, and you'll have probably some kind of bond hearing in Division 15, and I don't know what the schedule is for either of those. The judge. I'm sorry?
May 23rd for the VOP hearing.
Okay, so May 23rd for your VOP hearing, and I can't tell you when the one would be in Division 15.
Okay.
All right, thank you, sir. All right, and are you Mr. Bowman?
Yes, sir.
All right, Mr. Bowman. We're here on a couple of cases. 19 CO 563. You're qualified to be represented by the Office of the Public Defender, so I'll appoint them to represent you today, sir.
Sorry.
Your Honor,
Does he want to resolve both cases?
yes, Judge.
Okay. Yeah, he's got two, this one and another, so.
Judge, I don't think that I have the other one in front of me. Is it another soliciting without a permit?
Exactly,
And the answer-
2019 444.
Then the answer is yes, he absolutely wants to resolve both of them. It's an adjudication and credit for time served.
All
court
right,
costs.
how many days does he have?
Be pleading no contest to both.
Thank you. Sir, I'm being handed a form. Did you have a chance to read this form?
Yeah.
Okay, and is this your signature on the form, sir?
Yes, sir.
Are you under the influence today of any medication, drugs, or alcohol that would affect your ability to understand what's going on in court today?
No, sir.
And, sir, are you on probation in any other case?
No, sir.
Do you have any questions about the rights that you're giving up that are identified on this form?
No, sir.
Do you understand that if you're not a U.S. citizen, entry of this plea would result in your deportation?
Yes, sir.
And, sir, is it your desire to plead guilty to the charge of solicitation without a permit in case number 2019 CO 444? And solicitation without a permit in case number 19CO563.
No contest.
All right. And I will accept your plea. I adjudicate you guilty. I sentence you to 2 days in the Orange County Jail with credit for 2 days' time served. So you're going to be responsible for court costs. Those have to be paid within 1 year from today's date. And you have the right to appeal the ruling today. Any notice of appeal must be in writing and filed within 30 days of today's date. Okay, sir?
Yes, sir. Thank you.
Thank you. Good luck, sir. Sir, are you Mr. Rodriguez?
Yes, sir.
All right. Sir, you are here on case number 19CO962. You're qualified to be represented by the Office of the Public Defender, and I'll appoint that office. Is there a desire to resolve this case today?
Yes, Judge.
Judge, the offer in this case would be a withhold of adjudication and court costs.
Withhold and court costs?
That's correct, Judge.
All right. You want to fill out the form? All right, Mr. Rodriguez, I have a form here, sir. Is this your signature on this form?
Yes, sir.
Before you signed it, did you have a chance to read it and understand what you were signing?
Yes, sir. Yes, sir.
And do you understand the form?
Yes, sir.
Do you have any questions about the rights you're giving up?
No, sir.
Okay. Are you under the influence of any medication, drugs, or alcohol that would affect your ability to understand what's going on in court today, sir?
No, sir.
And do you understand if you're not a U.S. citizen, entry of the plea would result in your deportation?
Yes, sir.
All right. And is it your desire, sir, to plead no contest to the charge of alcoholic beverages, open container, in violation of a city ordinance?
Yes, sir.
All right, I'll accept your plea. I will withhold adjudication and impose court costs. Those will be due within 1 year from today's date, sir. And you have the right to appeal. Any notice of appeal has to be in writing and filed within 30 days of today's date. All right?
Yes, sir.
Good luck, sir. I'm sorry? It was a withhold. Well, I guess I could do that. Never mind. I think, though, if you do a withhold, you don't impose the time served because then it triggers a probation requirement, correct? So you don't give credit for time served.
That's only on felony cases.
That's only felony,
Yeah, I don't
okay.
think that's accurate, sir.
Good deal. All right. Is this Mr. Salvador?
Yes. Yes, sir.
All right. Sir, it looks like you do not qualify for representation by the Office of the Public Defender. Are you intending to hire counsel?
Yes.
I'm sorry?
Yes, sir.
Okay. You're entitled to be represented by counsel. Sir, in this case, 19 MO 963, you are charged with camping, prohibited camping. You don't qualify for PTR, so I am going to find probable cause and impose a bond of $250.
Your Honor, I know he's not represented by the Office of the Public Defender, but the offer, if you wanted to resolve the case today, would be a withhold of adjudication and court costs.
Okay, and I can appoint the public defender as friend of the court for today's purposes, if you like.
I want to get this over, so.
All right, thank you. Sir, did you have a chance to read this form before you signed it?
Yeah.
Is that your signature on the form, sir?
Yes.
And do you understand the rights you're giving up on this form?
Yes, I do.
And are you under the influence of any medications, drugs, or alcohol that would affect your ability to understand what's going on in court today?
No.
Are you on probation for any other case?
No.
Do you understand that if you're not a U.S. citizen, entry of this plea would result in your deportation?
That is correct.
All right, sir. Is it your desire to plead no contest to the charge of prohibited camping? All right, let me ask you this. To the charge of prohibited camping, how do you plea?
No contest.
All right, sir. I'll accept your plea. I adjudicate you. What was this, a
It was a
withhold?
withhold, Judge.
All right, so I'll withhold adjudication, give you credit for time served, and you'll be responsible for court costs, sir. Those have to be paid within a year. And you have a right to appeal. Any notice of appeal has to be in writing and filed in 30 days. All right? Good luck, sir. All right, sir. Mr. Wonder. All right, sir, you're here on 19 CO 565. You qualify for Office of Public Defender representation, so I'll appoint the office to assist you. You're charged with soliciting without a permit. Wish to resolve that today?
Yes.
All right.
This one will be an adjudication of guilt with credit for time served, Judge.
And how many days?
All right, he'll be entering a no contest plea.
All right, thank you. Sir, been handed a form. Is this your signature on this form?
Yes, Your Honor.
And do you understand the rights you're giving up by entering this plea, sir?
Yes, I do, Your Honor.
And have you had ample time to read the form, sir?
I have, Your Honor.
Are you under the influence of any prescription medications, drugs, or alcohol that would affect your ability to understand what's going on today in
No,
court?
sir.
Do you have any questions about the rights you're giving up?
No, Your Honor.
Are you on probation for any other case?
No, Your Honor.
Do you understand if you're not a U.S. citizen, entry of this plea will result in your deportation?
Yes, Your Honor.
All right, and to the charge of soliciting without a permit, how do you plea?
No contest, Your Honor.
All right, and I will accept your plea, adjudicate you guilty, sentence you to 2 days with credit for 2 days' time served, impose court costs. Those are due and payable within 1 year of today's date. Sir, you have the right to appeal. Any notice of appeal has to be in writing and filed within 30 days of today's date.
Thank you, Your Honor.
Thank you. Good luck, sir. And I believe that's all.